National Housing Law Project. We are a support center for domestic violence agencies and legal services programs across the country. We provide training and technical assistance on a variety of housing-related issues. In the presentation, we'll mention the various resources that are available to you on our website, but we do encourage you to contact us directly if you have any housing-related questions that are related to survivors of domestic and sexual violence. We're very fortunate today to be joined by two additional presenters, Kate Waltz, who is Director of Housing Justice at the Shriver Center in Chicago, as well as Catherine Bishop, who is a senior attorney here at the National Housing Law Project as well. Before we get started, I wanted to go over with you the GoToWebinar Interface. So on the left-hand side, you should see on your screen a viewer where you can see the PowerPoint presentation. On the right, you have a control panel. This is a great time for you to test the audio quality of the presentation. So if you're having trouble with the audio, you can use the telephone or the computer's mic and speakers. To use the computer's mic and speakers, you need to select mic and speakers on the audio pane. You can also minimize the control panel by clicking the double arrows, and you can make the control panel big again by, once again, clicking the double arrows. Your other option for audio is to just use your telephone. And you can do so by just going to the audio pane and selecting telephone. And then you'll see that there's dial-in information that you can use to connect to the webinar via the phone. Today, everyone in the audience is muted because of the audience size, but we welcome you to submit questions via the question box here. And we will try to answer all the questions that we are presented with. But if there are too many questions, we'll try to get back to you individually with answers. Just a note about our technology. Unfortunately, this morning we were experiencing some technological difficulties with our computer system. So if you find that for some reason your slides are not forwarding or it seems like your presentation is frozen, but your audio is perfectly fine, it may be that there's something going wrong on our end in terms of the computers. So we encourage you to just follow along with the printout or the separate PowerPoint presentation that we sent to you via PDF document, and you can just follow along using the audio that way. Just a few more housekeeping tips or a few more housekeeping items. The materials were emailed out to the registrants earlier today, and we're going to be emailing them out again after the webinar along with evaluations. The materials and the recording for this webinar will be posted at this address on our website, nhlp.org/OVW-grantees. And then for attorneys in California who are seeking MCLE credit for this webinar, we will be sending out MCLE certificates in about a week after the webinar. So with that, I'll go ahead and begin the presentation. So today we have two main goals for the webinar. First, we want to review and discuss the continuing and new housing protections under VAWA 2013 for survivors of domestic violence, dating violence, sexual assault, and stalking. We also want to spend a bit of time doing an overview of the federally assisted housing programs that are covered by VAWA 2013. As some of you are aware, there are a significant number of additional federal housing programs that are being covered by VAWA that were not previously covered by VAWA 2005. So we thought it would be good to give you sort of a short overview of these various programs. A couple of other things to note about VAWA. So in addition to VAWA, domestic violence survivors may be also protected under other types of laws, and these include state landlord-tenant laws, state fair housing laws, as well as the Federal Fair Housing Act. And I know before the webinar, we received a couple of questions about, sort of how VAWA intersects with the Federal Fair Housing Act or local fair housing laws. And unfortunately, because of the amount of material we need to cover today with VAWA 2013, we won't have any time to cover how VAWA intersects with fair housing laws. But we will likely have a webinar on a future date about how VAWA intersects with fair housing laws. So please stay tuned. In the meantime, we do encourage folks, advocates as well as attorneys, to look at a HUD memo that Sarah Pratt came up with that's entitled Assessing Claims of Housing Discrimination Against Victims of DV under the Federal Fair Housing Act as well as VAWA. And it was included, we have a link on our website, and I believe we included it in our materials as well. And that memo is great because it basically lays out the various potential fair housing claims that a survivor could allege, as well as giving you some more information about potential VAWA violations. For folks wondering about what sort of state or local protections are available in their particular jurisdiction, NHLP has a 50-state compendium of domestic violence laws, which you can access at this website address. And so that might be handy for some advocates as well. Okay, so a few notes about VAWA reauthorization in 2013. We want to clarify a few points about VAWA. So VAWA was enacted in 1994. It was reauthorized in 2000. And then it was reauthorized again in 2005, and then again recently in March of 2013. The reason why we have this particular bullet point is because we've received a few questions where there seems to be confusion about whether or not, because VAWA was not reauthorized in 2012, somehow the statute was not in effect. So VAWA was not reauthorized in 2012. But that lack of reauthorization pertained only to funding. It had nothing to do with whether or not the statute was in effect at that time. The statute was not repealed, so the statute was in effect, and the VAWA 2005 provisions were still valid. VAWA 2013 maintains VAWA 2005 housing safeguards, expands the housing programs to which the law applies, and adds new protections, and we'll be going over both of these continuing protections as well as the new protections today in the webinar. The VAWA 2013 housing protections are effective now. Some of the amendments require changes to the regulations or actions by federal agencies for purposes of implementation, but most of the provisions are self-implementing, so landlords and managers of the covered housing programs have to follow them right now. We've also received a few questions about sort of, when is the statute actually effective, and it was effective as of when the President signed the bill into law, which is March 7, 2013. So a note about sort of mechanically what VAWA 2013 did. So VAWA 2013 streamlines the housing protections for all the covered housing programs by repealing many of the prior provisions that have been replicated in several program statutes and consolidating them into a new section of VAWA. And so for the folks who are more familiar with sort of where VAWA 2005 was located in terms of, where legally, where the citations were, what the citations were, you might recall that, they had certain sections in 42 U.S.C. 1437F, and other provisions in other housing program statutes. So all of that has been stripped, and everything has been consolidated into a newly created section within VAWA. And the legal citation for that is 42 U.S.C. section 41411, which is highlighted in red here. Throughout the presentation, what we've tried to do is wherever VAWA 2013 has created something new that we did not see in VAWA 2005, we try to highlight that in red so that you know that, okay, this is something new, this did not exist before. And then a final note about the regulations for VAWA 2005. So as you can imagine, HUD has not come out with any implementing regulations for VAWA 2013. But the regulations that are currently on the books for VAWA 2005 are still in effect and are still valid. And you can find these regulations at this Federal Register notice The regulations continue to apply to public housing, voucher, project-based Section 8 programs. They also contain a lot of helpful language on several issues affecting domestic violence survivors, which we'll go over today. So during this webinar, we're going to be, like I said, reviewing a lot of the continuing protections as well as new protections. But what we wanted to do is create a one-page slide for you where you could, where essentially you could hand this to someone, or if someone asks you, well, what are the key points of VAWA 2013? How is it the same? How is it different? That you would have sort of this one-pager reference. And so we created this for you. Hopefully it is helpful. So VAWA 2013 continues the following. Survivors applying for HUD-subsidized housing. It protects against evictions and subsidy terminations, facilitates safety moves for survivors with Section 8 vouchers, that pertains to portability, permits lease bifurcation to remove the perpetrator from the unit. There are rules for proving DV, dating violence, or stalking. VAWA 2013 also continues to obligate PHAs to have plans and goals and describe PHA programs to assist survivors. The new protections under VAWA 2013 are, like I mentioned earlier, it covers many more federal housing programs. It actually adds about 2 million additional units under VAWA protection. It protects survivors of sexual assault and LGBT survivors. Sexual assault is a new category. And then within the domestic violence definition, you'll see that there's new language about intimate partners. So that is trying to extend the coverage to LGBT survivors. Rights for survivors remaining in housing after lease bifurcation. It expands documentation rights to show abuse. So under third-party verified documentation, there's additional category of professionals who can also provide for the third-party documentation. What landlords may do when there are conflicting certifications. There's also language about developing model plans for emergency transfers. And there's also language about mandatory notification that housing providers have to provide concerning VAWA housing rights at 3 critical junctures that have to be available in multiple languages according to a HUD guidance that we'll go over quickly today. So with that, I will turn the webinar over to Catherine Bishop, my colleague here at the National Housing Project.
Thank you, Carlo. So as Carlo mentioned, I'm going to try to go over, give you a brief introduction to the other federal housing programs to which VAWA is applicable. And this chart here, following, as Carlo had indicated, the new provisions are highlighted in red. The existing provisions that existed prior to VAWA 2013 are in black type, so that as those of you who have been doing VAWA work already, or for those of you who are new to it, the VAWA 2005 was applicable to conventional public housing, Section 8 vouchers, project-based Section 8, 202 supportive housing for the elderly, and 811 supportive housing for people with disabilities, was covered in the regulations issued pursuant to VAWA 2005, although they are not specifically mentioned in the statute. Those 2 programs now are specifically mentioned as being covered, and they are included, listed in the statute for 2013. There are new programs that are now protected by VAWA. They were added by VAWA 2013. And there are new HUD programs. So the first list here is listing those new HUD programs, Department of Housing and Urban Development programs, that are now subject to the protections and responsibilities of VAWA. So that goes for Section 236, which is a multifamily rental housing program. It's an old program that's been around for a while, so that those are existing units in your community. There's also a program called Section 221D3, BMIR, below market interest rate. Some people call them Beamers. There is also the home program. That is money that comes into your community from the federal government, and the local jurisdiction determines how that funding will be spent. There's also HOPWA, Housing Opportunity for People with AIDS. And then there are a number of homelessness programs, all of which we'll be talking about later, more specifically in some of the slides. In addition to the HUD programs, all of the multifamily rural development programs are now subject to VAWA, as well as all of the tax credit properties, low-income housing tax credits. You will also sometimes hear that referred to as LIHTC. So those are the new programs that are covered, and many of the provisions of VAWA, as Carlo has indicated, are applicable to these owners and developers now. And the survivors of domestic violence have the rights set forth in VAWA as they are living in these or applying for these housings. So again, I'm going to try to, what follows is a very brief overview of the federal housing programs. Try to talk about some common characteristics, some unique features, and then most importantly, for those of you who are doing advocacy at the local level, how you can determine where that housing is located, or if you're representing a client, how you can determine whether they're applying for that housing or living in that housing. So one of the common features is that the housing is owned. Of course, the commonality then stops at that point, because it may be owned either by a public housing authority, sometimes a state or local government agency, often by a nonprofit, and then also that some of these housing programs can be owned by a for-profit or limited partnership. It's important to know who is the owner of this kind of housing, because sometimes, for instance, in the instance of a nonprofit, there may be a board that this nonprofit responds to, and that may be another point of intersection in terms of trying to influence the policies for that particular housing or to resolve the particular issue that you're confronting. In each of these kinds of housing, there is a regulator. Now, the regulator, in all instances, there's going to be a federal department that regulates it. As the prior slide showed, there are many of the housing programs that are now covered by VAWA are regulated by HUD. There are multifamily properties that are regulated by the Department of Agriculture. And then at the local level, it's the Rural Development Office that regulates the RD, or Department of Agriculture housing. And then the regulator for the low-income housing tax credit, or LIHTC housing, is the IRS. In each of these housing also, there may be a state or local agency who is also a regulator. And in addition to that, for the HUD programs, some of them are regulated by a contract administrator, so that HUD has contracted out its regulating function to a contract administrator. And again, it's important to understand that structure. So as with the ownership structure of the building, the way the housing is regulated, again, gives you points of involvement where if you're having a problem or want to change a policy and you're not having any success at one level, you can take it up another level and hopefully get the issue resolved. Again, continuing with some of the common issues that are common features of the federal housing programs. Admission is generally restricted to low income, which is defined as a percentage of area median income. And there, for each of these housing types, there also may be targeting to the lowest income families for a certain percentage of the units. And some of this housing may have particular preferences, and those preferences may include things like preferences for individuals who are homeless or preferences for survivors of domestic violence. For those of you who are not familiar with your area median income for your jurisdiction, you can find that on the HUD website in a site called huduser.gov. Rents for all of these developments are overall generally below market, and for some of the largest programs, rents are a percentage of family income. Another common feature of these programs is that for many, but not all of the programs, there is a lease or a lease addendum that is a HUD document or an RD, rural document, that is a required form that the owner and manager must use for the development. For most of the programs, there are at all times eviction or termination protections. Good cause is generally required, but of course there are exceptions that we'll talk about, and the primary exception is for the voucher program. After the initial lease term, the landlord can evict without good cause. That doesn't mean the family's terminated from the program, but there may be an eviction without good cause. To give you a sense of what we're talking about in terms of the number of units that are available, we prepared this chart. As you can see, the voucher program is the largest program, followed by the low-income housing tax credit program. Then there is the public housing and Section 8 program. They're slightly above, they're approximately hovering at about 2 million units. And then there is the smaller RD program. Other programs that we've talked about so far are not even on this chart, primarily because there is no national data available as to exactly how many units there are of this housing, and also it's a very small slice of the pie. And of course you also know from your experience locally that the federally assisted housing programs do not meet the need of families in your community. Nationwide, it serves only about 1/4 of the eligible families. And then again, some of the data here will show duplications because, for instance, in a low-income tax credit property, you may have a voucher tenant residing in that unit, or there may be some project-based vouchers in that low-income housing tax credit unit. So what are some of the rules with regard to the HUD programs? And again, I'm trying to cover all of the HUD programs so that there's obviously going to be variations, and for every statement that I make, there may be someplace in the country an exception to that rule. So for instance, public housing. On the slide it says owned and managed by a housing authority. Now some housing authorities have contracted out the management of their public housing, and In some instances, if that housing was rehabbed and it now has tax credit on it, it may be owned by, and no longer owned by the housing authority, but it may have public housing units in it. For the voucher program, the housing subsidy moves with the family. That doesn't change. That's true throughout the country. Project-based Section 8 generally is privately owned and subsidized, and the subsidy doesn't move with the family. There are exceptions with respect to who owns that property. 202 housing, as I've mentioned before, that's supportive housing for families whose head are elderly. And I emphasize the term head, as children may live in 202 housing for the elderly. And in some instances, if it's a survivor of a surviving tenant, because the head of household has passed away, that surviving tenant does not necessarily have to be elderly. 20811 housing, supportive housing for families whose head is disabled. 236, 221D3 BMIR, privately owned generally, and has some HUD rent controls on it. The home program, as I mentioned previously, federal money comes into the jurisdiction. The local jurisdiction knows where this housing is located, and they have either developed it or put rental subsidies into it. HAPWA and McKinney Act, McKinney-Vento housing, you may know that at the local level as being shelter plus care, supportive housing, Section 8 SRO, or single room occupancy, or you may know it as continuum of care housing. Rural housing, RD housing, at least when it was initially developed, is located in towns with less than 20,000 in population or within a standard metropolitan area of less than 10,000 in population and rural in character. Over time, some of these units are no longer in areas that you would consider rural. Tax credit property, there's restricted rents. Those rents do not change with family income, and they are set at a flat rent, and that flat rent is 30% of a family in the jurisdiction with income at 50% of area median income, or the rents may be set at 30% of 60% of AMI, area median income, and it's the owner that develops the housing that gets to choose, or the state finance agency that allocates the tax credits determines what kind of priority they're going to get, and may give a priority for units that serve lower income. To help you identify the housing program, there is a chart that we've attached to our materials, Federal Housing Programs in Brief, that you should refer to, that provides some information in terms of regulations, statutory provisions. We've also given you an outline for public housing, project-based Section 8, vouchers, multifamily, which covers 221D3 and the 236, RD, or rural housing, and the low-income housing tax credit, also known as LIHTC. And in the outlines, there are links to how you can find each one of those housing developments that's available, at least publicly, on a national level. We've provided this additional link because we didn't have it on our outline to begin with, and the preservation database now has tried to compile all of those databases for each one of the programs into a single database. I know that from looking at it that, for instance, like for public housing, it will list some public housing developments in a jurisdiction, perhaps not all. And it does not include, I don't believe, all of the current project-based voucher programs, so that it's as good as it gets, but you may find that there are differences when you are working in the community and you get more information about the available housing, but it's a very, very good starting point. So now on to VAWA 2013 and what are some of the new protections. VAWA covers people who are subject to domestic violence, dating violence, stalking. There is, in 2013, the addition of adding victims of sexual assault, which includes any non-consensual sexual act prohibited by law, and that includes federal, state, or tribal law, and also includes when the victim lacks the capacity to consent. That's highlighted in red on your screen because that's a new provision, not a new provision to VAWA overall, but a new provision with respect to the housing protections of VAWA. Another addition to VAWA 13 into the VAWA Act is the definition of an affiliated individual. That definition, when you look at it, for those of you who are familiar with the regulations implementing VAWA 2005, you will find the definition very similar to an immediate family or any individual living in the household. That definition that is in the regulations regarding immediate family member are very similar to an affiliated individual as set forth in VAWA 2013. So what does VAWA 2013 do? It continues the protections that were in 2005 VAWA, in that PHAs shall not deny any applicant housing on the basis that the applicant is or has been a victim of domestic violence, dating violence, sexual assault, or stalking. And it now adds, because it's now covering additional programs, that landlords and owners of all the programs listed on the prior slides also shall not deny an applicant housing on the basis that the applicant is or has been a victim of domestic violence, dating violence, sexual assault, or stalking. So here, just to engage you a little bit, the 296 of you who are listening in on this webinar. Ida, she fled her public housing unit. We're going to ask you a poll question after this. After being attacked repeatedly by her abuser, Ida notified the PHA that she had moved out, but the PHA continued to charge her for rent after she left. 2 years later, Ida's name was at the top of the Section 8 voucher wait list. The Housing Authority, the PHA, refused to process her application unless she paid back the rent on her public housing unit. So, did the Housing Authority's rejection of Ida's application violate VAWA? I'm assuming that you all are seeing this poll question now. I'm going to close it in a minute. Okay, I'm going to close the poll question, assuming that you Most of you have voted. Hope that's right. And now I'm sharing the results, and you'll see that the vast majority of you answered the question correctly. That 82% said yes, 4% said no, and 14% are unsure. This is a violation of VAWA because in this instance, the Housing Authority knew that the victim had fled her public housing after being attacked by her abuser. She then applied, although I suppose this is not clear from the problem, she applied to the same Housing Authority and was at the top of the wait list. But this issue of financial harm that results to an applicant because of the domestic violence and how this can trail her and sometimes be a barrier for obtaining additional housing. For instance, evictions show up on a record. A family is trying to port, and the port is denied. These are things that many times you need to negotiate. You need to talk to your housing authority about how this happens and how it's related to the domestic violence. Evictions and terminations. Public housing authorities, landlords, and owners may not deny assistance to terminate assistance for or evict a tenant on the basis that she is or has been a survivor. Again, this applies to all of the housing programs we've been talking about, not only the prior programs of public housing, voucher, project-based Section 8, 202, and 811, but the additional ones of RD, LITAC, and the additional HUD programs. Crimes against a survivor directly relating to the abuse are not grounds for evicting the survivor or terminating her rental subsidy. There are problems, of course, with the issue of directly relating. That's not specifically defined in the statute. An incident of actual or threatened domestic violence doesn't constitute a serious or repeated lease violation or good cause for evicting the survivor or terminating her rental subsidy. And here's a note here just for those of you who are in rural areas. The Department of Agriculture RD form lease that owners and managers are required to use has a provision: all perpetrators will be evicted while the victim may remain, and that provision was added to their form leases before RD properties were made subject to VAWA, and so it should be in your leases even though it isn't specifically a VAWA, didn't flow from VAWA. So now we have Sonya. Sonya is a Section 8 voucher tenant. And the facts of that case in brief are that Sonya's boyfriend, John, cut himself while breaking into her unit. The security guard responded to the incident and made a report to management. Soon after, Sonya received an eviction notice for nuisance due to, quote, several domestic disputes between you and John. Sonya had several police reports and a restraining order documenting the perpetrator's violence against her. And the court ended up saying that the landlord was prohibited from evicting Sonya under VAWA. So there is some authority out there for, or a fairly substantial amount of authority, saying that the victim of domestic violence cannot be evicted for activities directly relating to the abuse because they are not grounds for evicting the survivor or terminating her subsidy. There are, of course, and those are the hard cases that you all deal with, that public housing authorities and owners still can evict if they can demonstrate an actual and imminent threat to other tenants or employees of the property. The terms actual and imminent threat are not defined in VAWA. However, they are defined in the HUD regulations. Those are the HUD regulations that cover the 5 programs that were covered under VAWA 2005. And it's important to know that this definition is in the current regulations, because we believe you can look to that current definition and say that certainly they're applicable to the 5 programs that VAWA of 2005 covered, but you should also be able to argue that they apply certainly to the other HUD programs, because these are HUD regulations. It may be somewhat harder to apply the definition to the LIHTC or RD programs prior to those agencies issuing regulations, but I still think you can make the argument that this is a reasonable definition of what is actual and imminent threat. So what do the existing regulations say about an actual or imminent threat? It defines the term threat, that it consists of a physical danger that's real, would occur within the immediate time frame, and could result in death or serious bodily harm. Factors to be considered include 4 factors: duration of the risk, 2, nature and severity of the potential harm, 3, likelihood that the harm will occur, and 4, the length of time before the harm would occur. And the cite there is to that definition in the Federal Register, in the CFR. And significantly, the CFR also says that eviction should occur only if there's no other action to be taken that would reduce or eliminate the threat. What about removing the abuser from the unit? VAWA 2005 allowed a housing authority or a Section 8 landlord to bifurcate a lease and evict only the tenant who commits the domestic violence while preserving the survivor's tenant's rights. This provision, of course, is subject to state and local law, and unfortunately there's no real guidance on how this will work locally. I think it's going to work best if the abuser is out of the unit and there's a protective order. Victim goes to the owner and says, either issue me a new lease or bifurcate the old lease. There are probably concerns about if the landlord is going to bifurcate the lease without talking to the survivor, whether there might be security issues if, in fact, the landlord starts to bifurcate the lease, which certainly should be discussed with the victim before that happens. There are significant new protections regarding bifurcation that also will help you in your arguments in related situations. Let's assume, and those new provisions say that, and they're in red on your slide, that if the individual who is evicted is the sole tenant eligible to receive the housing assistance, the PHA or owner must provide the remaining tenant who may not be eligible for that housing an opportunity to establish eligibility or a reasonable time to move or establish eligibility for another covered program. There's no definition right now of what is a reasonable time. That will come out in regulations, but at least right now, to the extent that the abuser has moved out, he was the individual person who was eligible, you might be able to convince an owner or a manager that the survivor should have some reasonable time to establish her eligibility or to some reasonable time to move. These cases arise generally when the victim is not a citizen or doesn't have qualified immigration status. It also may arise in a fairly unique issue with elderly housing, where the elderly individual is the abuser, that individual has moved out, the survivor is not elderly, and under the 202 rules, that individual would not be allowed to remain because they're not elderly, and the individual who was eligible, who is elderly, moved out as opposed to having died. Removing the abuser from the voucher, the housing authority may terminate Section 8 assistance to the abuser while preserving assistance to the survivor. So if a family breaks up from domestic violence, the public housing authority must ensure that the victim retains the assistance. There's the cite to the regulation for that. And you should probably consider asking for the voucher to be assigned to the survivor during any restraining order, divorce, or separation procedures to make that clear. We're now moving on to portability, and I have the pleasure of passing this on to Kate, who will now discuss portability.
Thank you, Catherine. So voucher portability, very broadly, has been in place where a Section 8 voucher holder, as Catherine described before, where the voucher is with the person, the subsidy is with the person as opposed to the unit. That person can move from their housing authority jurisdiction to another housing authority jurisdiction. And there are procedures in place called portability that allow them to do that. Prior to VAWA 2005, what advocates were seeing is that a voucher holder who was experiencing violence would leave their unit in violation of the lease, and then that allowed the housing authority to terminate their subsidy, even though they were leaving that unit due to an act of violence against them or a member of their household. So since VAWA 2005, VAWA now says there's an exception for survivors who must move for safety reasons. And so if they moved out of the assisted dwelling unit prior to getting PHA permission, oops, I hope that wasn't me, in order to protect the health or safety of an individual who is a victim of violence and who reasonably believes that she is imminently threatened by harm from further violence if they remain in the unit. Now, prior to VAWA 2005 and thereafter, housing authorities were allowed to limit what moves voucher holders made within the first year of their lease or from moving more than once during a 12-month period. And you would see this language fairly typically in the administrative plans for the housing authorities. The VAWA regulations clarified that these provisions limiting when Section 8 voucher holders can move did not apply in instances where someone needed to move for safety purposes, recognizing the practical that if you're moving for safety reasons, you shouldn't be hung up by these sort of arbitrary cutoff dates of moving. One problem, unfortunately, noted with the portability provisions is that they remained unaltered with the 2013 reauthorization. And this, we believe, was inadvertent. And so sexual assault is actually not listed in the 2013 reauthorization because that provision under 2005 did not change. And so advocates should make sure that this protection is clarified and push that the sexual assault be included in the implementing regulations. It was certainly the intent of Congress to provide all the same, and in certain instances even greater protections to survivors of sexual assault. And so we will be working to try to clarify that. If you can go to the next slide. Thank you. Now I'm going to talk about emergency transfers. Probably one of the biggest issues highlighted by advocates before and after VAWA 2005 was that if you lived in a form of site-based federally assisted housing, like public housing, project-based Section 8 housing, 211, 8, we could go through the list, you were unable to transfer to another form of site-based federally assisted housing without running the risk of losing your subsidy. And so we would frequently say that a survivor had to choose between their safety or their subsidy. The intention of VAWA 2013 was to address that problem so that there was an ability of survivors to transfer without risking losing their subsidy. And there was some thought being put into the process by federal agencies, by the public housing authorities, owners and managers about how to do this. As some of you know, that there are processes for transfers already within public housing that are noted in the Public Housing Occupancy Guidebook, but they are by no means a mandate. Now, Section 8 vouchers are already portable, as we discussed, as well as project-based vouchers in certain instances and vouchers part of PBRA. Under VAWA 2013, it's mandated that each federal agency, so in this case HUD, the IRS, and the Department of Agriculture, adopt model emergency transfer plans to be used by PHAs and owners. At this point, this has not happened. The transfer plan must allow the survivor tenant to transfer to another safe and available unit assisted under a covered housing program. And the language does not specifically say that it must be the same covered housing program. And so it will depend on what these agencies do, if they will limit it that or if it will allow people to transfer across programs, which may be important, particularly in more rural areas where there's a smaller supply of federally assisted housing. The tenant must expressly request the transfer and must reasonably believe that she's threatened with imminent harm from further violence if she remains. For victims of sexual assault, they don't have to necessarily show that there's a threat of imminent harm. They can also show that the sexual assault occurred on the premises within 90 days of the request. And the transfer plan must be confidential so that the PHA owner or manager does not disclose the location of the new unit to the abuser. If you can go to the next slide.
It just takes a moment.
Sorry. HUD must establish policies and procedures under which a survivor requesting a transfer may receive a tenant protection voucher. And so this will be subject to appropriations and the availability of vouchers and some guidance from HUD as to who would be eligible. When we looked at this provision and talked to members of Congress and HUD about this provision, the sort of key objective was to ensure that, again, individuals who would not be able to access other forms of federally assisted site-based housing would have a voucher available to them, either because there is another federally assisted housing or because there's none that is available. Implementation issues. What can advocates do during this time period before there's the adoption of these model emergency transfer plans? Just to step back for a second, this is requiring them to develop a plan. It is not a mandate that everybody must be moved. And so it's up to the advocacy community to push for that and make sure the plans are as broad and as thoughtful as possible. In the interim, I think that you should continue to work with your housing authorities, with your HUD offices, to talk about what they can do already. Under, as I said, the Public Housing Occupancy Guidebook, they're already recognizing transfers. Under the HUD Handbook governing the project-based Section 8 program, they're talking about transfers. In the HUD regulations, in the discussions about when you can evict a tenant due to an actual and imminent threat, they're talking about using transfer as an option before actually proceeding with the eviction. And so in Chicago, what we've done, for example, is worked with our local HUD office overseeing the project-based Section 8 program, and they've encouraged the owners in the Chicago area to adopt an admissions preference for victims of domestic violence, dating violence, sexual assault, and stalking. And if there is an incident where we are alerted that someone needs to transfer, then the HUD office works to identify an available unit for that survivor. And from that, we've developed a network of owners who are willing to participate in this for the greater good. So it's something that you can do now, irrespective of the timetable that HUD has. Are PHAs and owners required to use the transfer plans? It is that they are to use those plans as set forth by HUD, so I would say yes. And is a survivor entitled to receive a transfer voucher if other transfer options are infeasible? That remains unclear. I think it depends on to what extent, how many vouchers there will be available and what protocol is prescribed by HUD. Proving DV, procedural requirements. This is how do you show that you are a victim of violence and needed the protection of VAWA. If assume that a housing authority or landlord seeks to evict because of a lease violation, the tenant says the violation is related to domestic violence. Currently, under VAWA 2005 and now, a PHA or landlord is free to take the tenant at their word, or they can ask the tenant to prove domestic violence. And when they say at their word, literally their verbal statement or other observations that the person is a victim of violence. Any request by the PHA or owner for proof must be in writing, and the tenant has 14 business days or upon any extension granted to provide proof of the violence. Go to the next slide. Thank you. There are three types of proof. There's a self-certification form that they were developed under VAWA 2005. And the first form is the HUD form 50066 for public housing and Section 8 vouchers. And the second form is the HUD form 91066 for the project-based Section 8 program. Under VAWA 2013, it permits housing authorities and owners to request certification via form approved by the appropriate federal agency, recognizing that there are now more federal agencies involved in overseeing and implementing VAWA. And that form must state that the applicant or tenant is a victim, state that the incident is grounds for protection meeting the requirements under VAWA, and include the perpetrator's name if known and safe to provide. Now, the two forms that have already been developed, 50066 and 91066, do require the victim to name the perpetrator. Since VAWA 2013 is already in effect, I think our recommendation would be that if it is either the perpetrator's name is not known or it is not safe to provide the perpetrator's name, that in filling out that certification form, the victim simply either strike that provision or say, not known or not safe to provide. And that would be in accordance with VAWA 2013. There's also a question that since these new forms approved by appropriate federal agencies have not been developed, as far as we know, should you continue to use these forms, and can you apply them to the other programs? We would say that HUD 91066 could be used with the Home, HOPWA, McKinney-Vento, BMIR 221D3, 236, 202, and 811 programs, in addition to the project-based Section 8 program. It's worth trying to use those there. It's a recognized form created by the HUD Office of Housing, and so it's worth trying to use that form. For the HUD form 50066, again, using that for the public housing and the Section 8 voucher program. You can also submit police, court, or administrative records. Administrative record is a new provision under VAWA 2013. And so it can be a record from a federal, state, tribal, territorial, or local entity, or an administrative record. Finally, it can be a statement from a third party, either a victim service provider, a medical professional, or a mental health professional or attorney. It is new, the addition of a mental health professional. And that form must be signed by both parties, by the third party and the survivor, under penalty of perjury.
So now we're going to do a poll question here. And so I'm going to launch the poll here. I'm assuming you can see on your screen is, can a housing provider require a tenant to provide third-party proof of domestic violence, dating violence, stalking, sexual assault in order to use VAWA's housing protections? Okay, many of you have answered. I'm about ready to close the poll and show you the results, and Kate can explain the results. Kate, I'm assuming you can see this, the results?
Here we go. Now I can see it. Ooh, it's close. 51% said yes, that they can require third-party proof, and 49% said no. The answer is no. They cannot require a tenant to provide third-party proof of domestic violence, dating violence, sexual assault, or stalking. The VAWA final regulations stated that an individual requesting protection cannot be required to provide third-party documentation. And so they can use the certification forms that have already been provided, or the PHA or owner can accept their own verbal statement or other evidence of the violence. There's one, I don't know if you want to go to the next slide.
Yeah, just hold for a second. Sorry, okay. Just a second here. It takes me a minute to get off. There we go. Oops. There we go.
Sorry, can you go back to slide 34? Thank you. Thank you. However, there is one exception to this, and this is where two household, and this is under VAWA 2013. In cases where there are two household members who claim to be the victim, and we often call this dueling certifications, and name the other household members as the perpetrator, the housing provider can require third-party documentation. This was actually addressed initially in the implementing regulations for VAWA 2005 and then included in the VAWA statute. We felt that this was the best way to address a problem that we saw throughout the country, that it was more likely than not that the true victim would be able to provide that third-party proof and resolve the dispute.
So we have another poll question here.
And the question is, can a covered housing provider deny a request for VAWA protections if the victim has third-party verification from a mental health provider or attorney?
And I'm having trouble for some reason getting to the next poll. Okay, here we go. Okay, I'm going to close the poll, share the results.
So 11% said yes, and 89% said no. And the 89% are correct. Mental health provider, as I said, was added to the list of third-party providers with the VAWA 2013. You should be aware of making clear if you're providing as a mental health provider or an attorney the third-party certification under penalty of perjury, noting the violence, that you are not waiving privilege. And what we've seen done by sexual assault and domestic violence coalitions at the recommendation of their general counsels is just an explicit statement in that letter saying we are not waiving privilege in this instance by providing this information. I think with that, I'm turning it over to Carlo.
Thanks so much, Kate. Before I get started on the section about notification and language access, I just wanted to make a slight correction to a statistic that I mentioned earlier. I may have misspoken about because, you know, VAWA extended coverage to so many additional federal housing programs. I may have said that there were 2 million units that were now covered, 2 million additional units that are covered by VAWA now that were not previously covered. But that statistic is actually 4 million. It's about 4 million. 2 million refers to actually just the tax credit programs that are being covered by VAWA. Okay, so VAWA 2013 included new requirements regarding notification and language access rights. Under VAWA, HUD is required to develop a notice of VAWA housing rights, quote unquote, called the HUD notice, for all applicants and tenants. Now, this statute does not provide any detail in terms of what exactly should go in this notice, what kinds of protections, what else should it detail. So it's really going to be up to us in the advocacy community to really advocate for things that we think should be covered within this notice. And also, you'll notice that this is a general notification requirement. So PHA's owners and managers must provide the HUD notice to all applicants and tenants, not just to survivors, it's to everyone. And they have to provide this notice along with the agency-approved self-certification form, which Kate mentioned before and went over the various parts of that. They have to provide both this notice and the self-certification form at 3 critical junctures. Once, at the time the applicant is denied residency. 2, at the time the individual is admitted. And then finally, with any notification of eviction or termination of assistance. The statute also mentions that HUD guidance prohibiting discrimination against persons with limited English proficiency, for short, we abbreviate LEP persons, is applicable, including specifically for the HUD notice. There were some questions before we started the webinar about what is this guidance What does it provide for? So we're just going to do a very quick review of sort of the key points that the HUD guidance provides. I just want to alert folks that in September we're actually going to have a separate webinar that's specifically focused on language access and the housing rights of survivors. So we're going to go into way more detail than we are today. So folks should definitely stay tuned for that webinar in September. But just briefly, the HUD final guidance is designed to assist recipients of federal funding to comply with Title VI of the Civil Rights Act of 1964. Title VI itself prohibits discrimination on the basis of race, color, and national origin in programs and activities that receive federal financial assistance. HUD, as well as RD, which has a similar proposed guidance out, has established that language discrimination constitutes national origin discrimination. So that's how you get that link between language access and national origin discrimination, which is prohibited by Title VI. The guidance also provides a number of steps for recipients that recipients should take to provide better access for programs and services. So one of the requirements under the guidance is that recipients of federal funding have to do this analysis called a four-factor analysis. This analysis was initially developed by the Department of Justice for federal funding recipients to determine what reasonable steps are needed to provide meaningful access. And there are four factors they have to consider in the balancing. So one is the number of LAP persons from a particular language group eligible to be served or encountered. And I just want to emphasize here that it's the folks who are eligible to be served or encountered, the LAP folks who are eligible to be served or encountered. They're not the folks who are presently being served. Because you can imagine a situation, and we've seen this time and time again, where, say, a public housing authority has historically not provided any kind of language assistance, no interpretation, no translation of anything. And so folks coming to them, are being denied services, are being told, well, we don't understand what you're saying, so we don't know what to do. And so they are essentially discouraged from seeking those services because of the lack of language access. And so as part of this analysis, HUD says you have to look not only just at folks who you're serving, but also folks that you could be serving if you had language access issues. So the investigation or the research has to go beyond just sort of immediately what do your records indicate about people who you serve. The second factor is the frequency of contact with LAP persons. Again, I would focus folks to the fact that they, recipients of federal funding should be focusing on folks that they could be serving, but for the fact that there are these language access barriers. 3, the nature and importance of the program, activity, or service for the LAP individuals. So affordable housing options are arguably more important than, say, a service where you're providing an optional parenting class. Housing is very important to survival. It's very important to the stability of both the survivor and her family, whereas a parenting class is not necessarily something that is required. And then the last element is the federal funding recipient is supposed to look at the resources available to meet the language access needs. So this includes the cost of providing the LAP services. So after completing the four-factor analysis and determining the language access needs, HUD advises recipients to develop an implementation plan to address the needs. And this is called language access plan. It's also been called a language assistance plan. In short, we call it LAP. HUD recommends that LAP contain certain topics, including how the recipient will identify LAP folks that need language assistance, information about language assistance that will be provided, staff training, as well as providing notice to LAP individuals, and also identifying vital documents. And I'll explain what vital documents are. So in this guidance, HUD indicates that quote-unquote vital documents should be translated. And vital documents are defined as documents that are critical to ensuring meaningful access to recipients' activities and programs. Whether or not something is vital is determined by looking at two things. So one, whether the importance of the program information or service. One is the importance of the program information or service involved. and 2, the consequence to the LEP person if the information is not provided accurately or in a timely manner. So a good example of a vital document in the housing context is a notice to quit. So a landlord wants to evict a survivor and her family from a unit. Obviously, it's very, very important to get this notice translated accurately and in a timely manner so that the survivor knows, oh no, I may be losing my housing, maybe there's something I can do about it. And obviously at risk is her housing, which is a vital, it's a vital resource, and if she were to lose it, she would also lose stability. If she has children, it also threatens her children's stability. So this notice would have to be translated. The Office of Public and Indian Housing, as well as the Office of Multifamily Housing at HUD, both offices have lists of documents that are considered vital and should be translated. And we'll go into more of that in our language access webinar. Next slide, please, Kathy. Okay, so there are a variety of implementation issues associated with these new requirements. We've been asked several times, what exactly are PHAs, owners, and managers obligated to do before HUD develops the notice? And so right now, PHAs and project-based owners and managers, they still have to comply with current regulations. The regulations are implemented under VAWA 2005. And so VAWA 2005 regulations tell us that these PHAs and owners, they have to use a HUD-required lease and lease addendum. So for example, for the project-based voucher lease addendum, as well as the project-based Section 8 lease, you see that there are actually housing protected provisions for survivors that are in those leases. And so PHAs and owners have to follow those. And as Kathy mentioned earlier, there's also a protected provision for survivors within the RD lease. What about notice to tenants and other covered housing programs? And then also, what can advocates and survivor tenants do during the interim period before HUD develops this notice? So we have been encouraging advocates to really work with the housing providers and PHAs on outreaching to them as well as educating them about sort of what are VAWA 2013 provisions. What does it require? What does that mean for me? And what can I do if I genuinely want to help survivors? And through our trainings with various PHAs and also owners, it really seems like a lot of them want to do the right thing, and they want to protect survivors and make sure that they have safe housing. And so we've been encouraging them to, adopt their own notices before HUD even implements this HUD notice, and work with local legal advocacy organizations as well as other advocacy groups to come up with a notice that they could provide to all applicants as well as folks who may be losing housing, and see if that could be distributed. And I can't emphasize enough how important outreach and education is because this statute is so new. Okay, other requirements that VAWA 2013 has, confidentiality. Like Kate mentioned before, the transfer provisions include language about confidentiality. And separately, VAWA also requires that landlords and owners keep confidential information that the survivor provides to certify the victim's certify her status as a victim, including the fact that she is a victim. So this information cannot be entered into a shared database or disclosed to another entity or individual unless the disclosure is, one, requested or consented to by the individual in writing, or required for use in an eviction proceeding to determine whether certain incidents qualify as a serious lease violation, good cause to evict or terminate, or if it's criminal activity directly related to the domestic violence. Or three, unless the disclosure is otherwise required by law. survivors also have to be held to the same standard as other tenants. So, for example, an abuser who is not on the lease breaks into the survivor's unit and causes lots of damage. And the landlord says, hey, you caused there's a lot of damage in this unit, and you have to pay for these damages, or otherwise I'm going to kick you out. But the survivor then learns that sort of a similar situation occurred where her next-door neighbor had a burglar break into their unit and caused similar damage. But the landlord told that tenant, you know, it'd be great if you could pay, but if not, you know, I'll do it, and that's okay. And you won't face any potential for eviction or anything like that. So clearly, the survivor and the non-survivor are being held to different standards, are being treated unequally, and that would be a violation of VAWA. So PHA plans. VAWA 2013 did not change any of the provisions regarding the PHA planning process. So a PHA still has to include in its annual plan a description of activities, services, or programs as to how it's assisting survivors. A PHA also has to include in its 5-year plan a description of goals, objectives, policies, or programs used to serve survivors' housing needs. VAWA 2013, similar to VAWA 2005, also provides that there's no preemption for laws that provide greater protections for survivors. And this is no preemption as they pertain to state and local law. So for example, in California, we have a number of state provisions that provide greater protections for survivors that apply to folks in all kinds of housing, not just the housing that's covered by VAWA. So for example, we have a provision that allows survivors to terminate their leases early, and they only have to pay 30 days of rent after the date of the notice of their intent to leave, to terminate the lease, and then they're off the hook financially. So that is fine and is allowed by VAWA. Impact on existing protections. VAWA does not limit any existing rights or remedies available under the housing program statutes and any of the VAWA 2005 regulations. And given the spirit of the statute and really the intent of the statute to expand protections for survivors, you know, we really think, and I think that, you know, we're really on firm ground that the implementing regulations for VAWA 2013 can only augment the existing regulatory protections. There are several areas that are quite unclear under VAWA. We have these particular bullet points because we tend to get quite a few questions about these various situations. And we mentioned them to just sort of flag them for you to kind of figure out how to give you if you are experiencing any of these situations, you know, the best thing to do would be to contact us directly. They're very fact-specific in terms of what kinds of next steps you could take. So we would be very happy to speak with you and analyze the situation for you and propose some next steps. But VAWA is not entirely clear on cases where the link between domestic violence and the lease violation is indirect, such as where an abuser is refusing to pay the rent. Situations where the survivor signed an agreement to keep the abuser off the premises or to repay damages caused by the abuser. Cases where the survivor repeatedly reconciles with the abuser, and also where exactly to file complaints if the PHA refuses to comply. Again, you know, folks who have questions about this, please contact us, and we can try to help you. We have a slide here on systemic advocacy. Like we mentioned, VAWA 2013 is a very new statute. There needs to be a lot of outreach and education to PHAs and owners about exactly what it provides. And I think there's also a need for just sort of general education about the dynamics of domestic violence, sexual assault, and stalking. As folks of us who work in it, do this every day, we know that there are a lot of stereotypes that are often used in sort of talking about survivors and what they should be doing, what they should not be doing in So I think there's quite a bit of education that needs to be done there. That does not have to be done by an attorney. You know, in our experience, PHAs and owners, like I said before, are very willing to work with advocates and legal advocates on sort of doing the right thing. And so I know in our practice we reviewed a number of policies of PHAs and owners and suggested sort of various ways that we think that the policies could be bettered and they could better serve domestic violence survivors. And so NHLP is really happy to you know, work with various PHAs on developing their policies. We also encourage folks to form a local working group composed of organizations such as transitional housing providers, legal services, domestic violence, and homeless advocates to address survivors' housing needs. We really encourage working groups and task forces where it's comprised of folks from different sort of sectors who are all kind of working with the survivors but in different ways, because we feel that this really provides sort of a holistic vision of sort of what the survivor really needs at the end of the day and coming up with a holistic solution. So this is a slide with resources that are available to you. Again, you can go to our website at that web address on the web page that's for OVW grantees. There's a lot of information there. Aside from just trainings and webinars, we have publications and a newsletter that we publish every month under our DOJ grant. We also, within your packet, we also have all these different things, resources on how to identify a federal housing program that may be involved. There's a side-by-side comparison chart between VAWA 2005-2013 that might come in handy if people really want to kind of focus on the language and see, well, exactly how does the language differ. There are also 2 articles in your information packet, one that's more for a non-legal audience and one that's for lawyers. And the one for lawyers is just sort of expanded a little bit and has legal citations. And that is our contact information. So I see that we are actually on the hour. It is now 12:30 Pacific time. But if it's okay with folks, I actually just wanted to spend another 5 to 10 minutes on the questions that came in. And is that okay with you, Kate and Kathy?
Sure, fine with me.
Okay. So first question is, does VAWA cover tenants renting from private landlords?
If there's no subsidy, as Kathy mentioned at the beginning of the PowerPoint presentation, then they would not be covered. But if the tenant has a housing choice voucher and they are renting from the private landlord, then they are covered.
Mm-hmm. And I would just add to that for folks who think that VAWA does not cover their particular situation, they should look to other kinds of laws that would apply. So for example, state landlord-tenant laws might provide some additional protection, as well as the various fair housing laws, both state and federal.
And just one additional thing is that just as an aberration, not that it applies to private landlord-tenant, but you often find, especially if the entity deals a lot with HUD and has a variety of programs and things like that, sometimes they pull out the wrong lease and use the wrong lease, and you may get some protections that way that are more of a gift than anything required by law. So do check out the leases that the tenants sign.
Okay, thank you. With the new sexual assault piece, does there have to be a conviction for proof, or is an order of protection / police report, etc., enough to get the assistance?
A conviction is not required for sexual assault or for any other type of violence covered by VAWA. So you look at the slide that goes through that they either can self-certify, that they take the victim at their word, they use one of the certification forms in place now or to be developed. They provide proof from a state court, police, tribal agency, or administrative record, or third-party certification under penalty of perjury. from a victim service provider, medical professional, mental health professional, or attorney. That I have to say, the proof requirements is one of the biggest misunderstandings I have seen by advocates, by housing authorities, by owners. Fairly typical insistence of you must have an order of protection. That's probably the biggest mistake I have seen. And that victims then don't seek out assistance because they can't get an order of protection. They've tried and are unable, or it's unsafe for them to. So it's really important to understand what you have to prove and what you don't have to prove.
And I would recommend, just to emphasize that point, that people just pull down and look at a copy of that HUD form. And all the victim needs to do is fill out that form with the modifications that Kate talked about whether or not you have to identify the abuser.
Okay, great. Thank you. Does the admission protection apply to McKinney-Vento programs?
Yes. It does apply to McKinney-Vento programs. All of the protections of VAWA apply to all of the programs listed. And so the admission protections apply today, now, without any additional regulations being required because the statute is self-executing.
Mm-hmm. So we have a couple of questions here about emergency transfers, and I'll try to kind of summarize them. So one person is asking, does the emergency transfer only apply if other housing is available? And then someone is asking, when is the transfer plan due? So maybe that is asking when this model transfer plan will come out.
Well, to answer the second question first, it depends on HUD and the other implementing federal agencies, but it also depends on all of us who care about this provision and wanted it for such a long time to push them to start putting that in place and inserting ourselves into that process and making recommendations as to what it should look like and how broad it should look. This question of if other housing is available, that's why the language is drafted to be somewhat vague as to going into another covered housing program. And it also is recognizing that the other option would be a voucher. Again, it's not a guarantee of a transfer. It's not a mandate that they must transfer everyone. It's a mandate that they create a plan about transfers. So there's going to be a lot of implementation work at the federal level and then at the local level with the working groups that Carlo mentioned. It's really important to get all of those voices in the room to talk about how essential this is.
Okay. Can you provide examples of administrative records as verification?
I'm trying to think of where this, I don't know that this is an issue for Illinois. If Kathy or Carla, if you have an example.
The only thing I can think of, and it's just because of the limitations of us focusing on housing, but let's assume that the tenant was evicted from public housing and went to a grievance hearing, all right?
Yeah.
And that grievance hearing indicated that there was the domestic violence, or that just the records of that housing authority indicate that the tenant notified the landlord or housing authority, I'm moving out, I'm getting away from this, I am fleeing domestic violence. So that would be the administrative record at that housing authority. And now that individual has moved from Oakland, California to Chicago. Chicago, they get on the Section 8 wait list, and now they are being denied because, let's say they owe a debt to that prior housing authority, but the tenant gets the record that they had on, that was created while the tenant lived in the public housing in Oakland, and provides that to the housing authority in Chicago. So it would be something that's created by an administrative agency that documents the violence.
Mm-hmm.
Okay. It doesn't say, although the rules don't actually say that it's got to be a governmental agency, but maybe that's just my interpretation of that, just because of, we deal with administrative agencies, and I don't think it answers the question whether or not can an administrative record, can a DV organization have an administrative record? I don't know the answer to that question, and I don't know how HUD would define that.
Mm-hmm. Mm-hmm. We're now at 12:40, so we're about 10 minutes over. There's still some questions that remain, but we're going to go ahead and just answer. We'll email those folks back individually and answer their questions that way. Is that all right, Kathy and Kate?
Sure. Fine with me. Yeah.
Okay. Well, thank you so much, everybody, especially to Kathy and Kate, for doing this webinar, and thank you to everyone who participated. If folks have questions, please feel free to contact any of us, and hopefully we'll be seeing you soon again. Thanks so much.
Bye-bye.